One of the most important deadlines under the REPC is the disclosure deadline that we established as the very first deadline. It's easy to make this a short deadline in an effort to try to make the contract move faster. However, it can put you into a very tight spot as a buyer and as a seller agent. Let's take a look at paragraph 7 of the REPC. Of everything that has to be provided by that disclosure deadline, or the party that is required to provide those, most frequently the seller, could be considered in breach of the contract by not having provided all the documentation required on time. First is a written seller property condition disclosure. They should be providing the complete seller property condition disclosure. As a seller's agent, you have a responsibility for making sure the name, address, and brokerage are filled out properly, and that your client has completed the form. We are not responsible for answering for them, but go through the form after you have received it to make sure all of the questions are answered. That any answers that require additional explanation, the explanation has been included. And thankfully, on the simplified version, it's much easier at the very end, whether or not make sure the square footage, where the square footage measurement you're using, where you gained that. County records, appraisal, building plans. If you're using a prior MLS listing, then mark other and put prior MLS listing. And then this has been simplified, but make sure this is complete if your buyer is subject to the Foreign Investment and Real Property Tax Act, then make sure that that is then marked. As the buyer's agent, once you've received this, you have responsibility for making sure all of the pages have been initialed and signed as received. The next form is the lead-based paint disclosure, making sure that that disclosure has been received and initialed and acknowledged by the buyer. As a seller's agent, making sure that paragraph 1 is properly completed with the address, statement of whether or not there are known lead-based paint hazards and where that information came from is signed, and then make sure, as the seller's agent, this must be signed when your sellers sign it. Buyer's agent, make sure that then initial whether or not they're going to take the 10-day additional opportunity or waive that additional opportunity, and it is signed, and that they have received a copy of the lead-based paint disclosure or the lead-based paint pamphlet from the EPA. We've received word recently the EPA is now auditing random brokerages to make sure that lead-based paint disclosure and the lead-based paint protect your family from lead-based paint pamphlet have been received. Commitment for title insurance. As an agent, make sure that there's adequate time for an updated title search to be completed. A very short disclosure deadline on a weekend could put the buyer and the seller both in a tight spot trying to get an adequate title search completed in a very short amount of time. Then review it briefly to make sure there aren't any clouds on the title or issues that may cause problems with title later. Check Schedule A so that you understand how much the title premium is going to be, and that the proposed amount on the buyer side and the seller side are both based on the correct amounts. Also, make sure to take a moment to look at Schedule B, Part 2, to make sure there are not any recent deed transfers that could affect the property. If there's been a deed transfer within 90 days, that will actually eliminate FHA, or if you are working with an FHA that transferred recently, to make sure that you have gone under contract on day 91 or later from the last deed transfer. Also check to see on Part 14, check your party's name to make sure there aren't any judgments that appear on there. Judgments can be put on there that they may not even be aware of or may have not told you about. We've had situations of unpaid child support, unpaid alimony, or other liens for unpaid credit card and commercial debts, such as RC Willie, show up on there that now have clouded title and may cause problems with the borrowing process. A copy of the covenants, codes, and restrictions and rules and regulations. And there's a separate video regarding that specifically. If you're having difficulty in gaining those forms, there is a request for homeowner association form on the MLS. It's also in Brokerment that can be provided to the HOA if the HOA is making it difficult to get those. Reminding the HOA that under Utah law, they have 5 days to comply with this written notice. As a listing agent, it is in your best interest to make sure that this is taken care of at the time you take the listing, so you're not trying to come up with those documents after you've gone under contract and are then on a bit of a time crunch. Any lease agreements that exist, any water rights are transferred on a separate water rights deed. When taking the listing, if water rights are involved, you should be working with title to make sure that title has ordered and received a copy of those water rights so that they can be adequately transferred, and to verify that the water rights that may be stated in the listing do in fact match the recorded water rights that are available to the property, so that the transfer of those can take place in a timely manner. All of those are required under paragraph 7 and must be provided by that deadline. It's in your best interest as a listing agent to have them all prepared, and as a buyer's agent to prepare your buyer to understand that they will be receiving a number of documents that they need to review as part of that disclosure deadline, so they understand as much about the property as possible.